The objection to the appointment of a public administrator as a personal representative. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover SCAO form PC 690. SCAO stands for State Court Administrative Office. PC is Probate Court, 690 is the form, so it's PC 690. At the bottom left corner, you'll see a little yellow arrow. It identifies both the statute and or court rules that apply to the particular form. In this particular case, MCL 700.3414 is the controlling statute. And this form is used in a very particular context. It's used when a petition has been filed with the probate court seeking the appointment of a personal representative, and the personal representative that is being sought to be appointed is a public administrator. The statute allows for somebody that has a right or an interest to seek the appointment of a public administrator by virtue of a petition for probate. So this would be after the petition has been filed and now somebody wants to object to that nomination as a professional public administrator serving in the role of personal representative. This is the form that's used for that very narrow use case. So as you can see in the top left corner, the court county would be identified in the top right corner, the case number. In red, you'll see the form is identified as the objection to the appointment of a public administrator as personal representative. Now again, if you don't know what a public administrator is a professional person that is appointed through the government that serves as an administrator when there isn't a family member or a nominated person within a will that would be serving. So it's like a professional fiduciary appointed. And these rules are governed by a body of statutes. We're not going to go over that right now, but that's what a public administrator is. It is somebody that is a government administrator of the estate serving as personal representative. In this particular case, the court address would be identified, and the matter of would be the name of the person that died, the decedent, the objecting party, and if there's an attorney, the objecting party's attorney. Pretty straightforward here. Number one says, I am an heir of the decedent named above, meaning they're an heir of that person that died. Two, I received notice of hearing to the rights and right to object, PC 689, regarding a petition for probate and appointment of personal representative. Three, I object to the appointment of. This would be the public administrator that is being nominated within that petition for probate. So the objection is for that person to get appointed and for the following reasons. Now you can imagine a following reason may be, well, I'm named in the will and I have priority over the public administrator to be appointed. Or I am the son of the decedent or surviving spouse or nearest heir at law, and I have a right in higher order of appointment than the public administrator. The public administrator only gets appointed under very defined and specific sets of circumstances, and they don't trump those people that are entitled under Michigan law who have priority for appointment of personal representative. So in Section 3, you have to flesh out and identify the basis for the objection and why the court should not appoint the public administrator, but rather should appoint somebody else. In the bottom section, the objecting party signature is there and the attorney's signature. And this particular objection would then be filed with the probate court. At the Probate Pro, we're passionate about everything probate. If you have questions about this particular form or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.